Extending the deadline for the SEC's Ripple lawsuit, Judge Analyst Torres of the U.S. District Court has granted the U.S. Securities and Exchange Commission's request to extend the deadline for submitting a response that might terminate its lawsuit against Ripple Labs. The court has issued this document as an official record. The Securities and Exchange Commission was given more time to provide the discovery papers it sought from Ripple regarding its remedies, according to court filings filed on March 1st. The regulatory authority now has until March 22nd to provide its opening brief due to the prolongation. Also, the SEC now has until May 6, 2024 to submit a response, and Ripple now has until April 22nd, 2024 to submit an opposing brief. We have extended both deadlines. Potential legal remedies and courses of action that could be considered or followed throughout the inquiry or litigation are detailed in a briefing that is linked to remedies. The SEC has asked for more time to complete the task. Beginning in December 2020, Ripple Labs was subject to legal action by the Securities and Exchange Commission. In addition, the SEC claimed that the company, its CEO Brad Garlinghouse and co-founder Chris Larson had engaged in a $1.03 billion unregistered securities offering. We were able to achieve this by selling XRP. Because of the SEC's belief that the token should be considered a security, it is subject to rigorous regulatory constraints. Nevertheless, Ripple insisted that XRP is not a security and that it was not adequately notified by the SEC. When asked about its classification, Ripple claimed the SEC did not provide them enough warning. A lot of change and legal dispute has occurred in the case throughout the years. The Howey test, used to determine if a transaction satisfies the requirements for an agreement to invest under U.S. law, is at the center of a contentious debate. From the perspective of the SEC, XRP passes the Howey test. But Ripple says that's not the case. A landmark event happened in July 2023 when Torres handed down a decision that was heavily favorable to Ripple Labs. Regarding its programmatic sales on digital asset exchanges, he concluded that XRP was not a security. This was a major turning point. In contrast, the judge ruled that XRP, upon presentation to institutional investors, constituted a security. Cointelegraph has contacted Ripple but has not heard back from the company as of this writing. Remarkably, the Securities and Exchange Commission has asked Judge Analyst Torres to grant a deadline extension until March 22, 2024 to file its opening brief on remedies. The SEC will have more time to review the discovery materials that Ripple has submitted regarding remedies, so they have postponed the deadline for their response from April 29th to May 6th. Meanwhile, Ripple has been given more time to submit its opposition brief, which will now be due on April 22nd instead of April 12th. There will be a one-week extension on the lawsuit. Despite the prospect of a settlement among Ripple and the SEC, the cryptocurrency known as XRP remains adamant that the case is nearing its conclusion. An important development in the ongoing conflict between Ripple Labs and the SEC has occurred in the lawsuit. A judge has signed an order pertaining to the SEC's request to extend the deadlines for remedies-related briefing, opposition to briefing, and reply the court's decision regarding the SEC's demand to extend the deadline. Despite Ripple's opposition to briefing and the Securities and Exchange Commission response to that opposition, a court record states that the judge has allowed the U.S. Securities and Exchange Commission's plea to reschedule the dates for remedies-related briefing. Securities and Exchange Commission wanted it. Based on our research, Torres has been granted a new date of March 22nd, 2024, rather than March 13th, 2024, to submit its opening brief addressing remedies. Ripple now has until April 22nd to file its opposition brief, and the SEC now has until May 6th to submit its reply. Both deadlines were previously extended from April 29th to April 29th. The SEC will have extra time to review the discovery papers that Ripple presented regarding remedies. Therefore, the action has been postponed by 1 week. Magistrate Judge Netburn had previously granted Ripple's plea to postpone the discovery requirements related to remedies by 1 week. After the case was filed, institutions were required to sell XRP and submit thorough financial statements. The XRP army is hopeful that the case is drawing to an end as Ripple and the SEC keep discussing the possibilities of settlement. But a measure to prevent the partial government shutdown has already been sent to President Joe Biden, and the SEC deadline is on the same day as the government shutdown. Last week, $1.07 billion poured into Bitcoin ETFs, and an analyst from Bloomberg predicts a decline. The verdict in the case of Ripple VC is drawing near. According to what CoinGov said earlier, the new April deadlines align with the final regulation changes that the SEC will make in April 2024 to better safeguard client assets while they are receiving advice. In response to the SEC's arguments about investment contracts, XRP advocate and lawyer Bill Morgan pointed out the major mistake in the SEC's view of investment contracts in relation to cryptocurrency. Finding a limiting principle is not feasible. The price of XRP has risen by more than 8% in the past 24 hours and is currently trading at a low point for the past 24 hours, according to him. He also said that the fact that an asset class is unique from all others does not justify an extremely complex and wide-ranging application of the Howey principle. In contrast, trading volume has increased significantly over the last several days due to a widespread rally in the cryptocurrency market, which is strong relative to the same time period. The SEC's ongoing litigation against Ripple Labs has been granted an extension by Judge Annalisa Torres. The argument over XRP has now taken a new turn. The regulator's request for more time to submit its discovery papers regarding remedies is a crucial step that could lead to the conclusion of the high-profile case. According to a report released by the Enquires last year, the Securities and Exchange Commission seat accused Brad Garlinghouse, Chief Executive Officer of Ripple, and Chris Larson, Executive Chair of the company, of malfeasance. The American payments company accomplished this after securing a partial victory in court. The deadline for the SEC to file its opening brief is March 22nd. The deadline for the SEC to file its opening brief is now March 22nd. Judge Torres granted this extension of time according to documents filed on March 1st. Furthermore, Ripple now has until April 22nd to submit its opposing brief. All of this happens simultaneously. It is expected that the SEC will provide a comprehensive document outlining potential legal remedies and measures linked to the ongoing dispute by May 6, 2024. This document is called a remedies-related briefing. The feud between Ripple and the SEC began in December 2020 when the SEC filed a lawsuit against Ripple Labs claiming that the firm, its CEO Brad Garlinghouse, and co-founder Chris Larson were involved in an unregistered securities offering involving the sale of the XRP cryptocurrency, which was valued at $1.03 billion. If XRP were to be considered a security, Ripple would strongly disagree. A recent turn of events has resulted in the XRP ledger blockchain experiencing a spectacular increase in the burning of XRP tokens. This amount of burning has reached an unparalleled level that has not been seen since the middle of January. The most recent information from XRP Scan indicates that a staggering 6,721.92 XRP were burned as commissions. This represents a remarkable 104% increase in comparison to the previous day's activity. The dramatic increase in the price of the popular token coincides with the growth in the number of burns experienced. Not only has the price of XRP increased by more than 15% over the course of this week, but it has also painted an outstanding weekly candle on its price chart. In spite of a brief setback that occurred earlier today, in which a wave of selling temporarily erased nearly 9% of its gains, the tenacity of purchasers quickly pushed the price back up to $0.624 per token. That's all for now.